Last but certainly not least, Professor David Weber.
Thank you, Pina, and thank you, I was going to say fellow authors, but I guess it's fellow content providers. And thank you for staying for what is usually called the graveyard shift. I'm glad to see we've got the real aficionados here. Very few seem to have left the room, so I guess this is a testimony to the quality of presentations about to come, and you better live up to it.
You want a sub for me?
Well, I'm very pleased to be able to introduce the two speakers on a topic which I think is quite usefully left to last, because it was raised, it's a sort of a bookend to the question that was raised right at the very beginning by Dan Rosen, who was saying, who told us about his exploits with his service provider or the site which hosted his material, and told him quite usefully to go and comply with American law and also the law of 150 other jurisdictions if he wanted to stay clean. So we are we're now going to talk about the 150 jurisdictions from two levels. The international, what's called the public international law side, that's the treaties and customary international law that binds all nations. And then what is called the private international law side, which when I was a youngster going through used to be conflict of laws, but none of us like conflict. So we've decided to call it private international law, and that regulates or that's supposed to decide such fascinating questions of if you do something wrong, which country's law tells you that what you've done is wrong, and where may you end up being sued or taken to court, both of which questions are quite vital. Because if you have to comply with the laws of 150 jurisdictions, I think you are in serious trouble. So with that, I will introduce, first of all, to your immediate left and my immediate right, Barry Suckman, who's, I won't introduce much more than say that he's a senior partner at McCarthy Tétrault and is a recognized expert in internet law, telecommunications law, and copyright law, and has written extensively in that field, both in texts, treatises, articles, and, dare I say, blogs. And to my father to my right is a great pleasure also to introduce Professor Joost Blom from the Faculty of Law, University of British Columbia, another good old friend of mine who actually combines the rare qualities in this area of having interests in both private international law, being an expert in that field from long, long ago, and coming from that area, falling into that area, being pulled into that area, and not screaming too loudly, into intellectual property. And the confluence of those two subjects is what we have brought him here today to talk about. So without further ado, I'd ask Barry to start talking about international law and UGCs.
Thank you very much, David. I want to start off by thanking Pina and IP Osgoode for their leadership in IP education in this country. Osgoode has one of the best, if not by far, the best programs in IP anywhere, and it's a real tribute to Pina and Karis and David, who've worked so hard to make the program a success. And an indication of that is this program, is them getting Victor, an internationally renowned academic, to be involved in this program and to provide a special course. So I think in the whole community we should all be really, really pleased with IP Osgoode, and you've got all of our gratitude. One of the first questions you may ask is, why the heck does anybody want to talk about UGC and international law. What's the relevance? After all, the section is already here, it's already enacted, so is this really only of academic interest? Is this really just the bookend to this morning's discussion? And I say there are at least 3 reasons why this topic is relevant. The first is, of course, intellectual curiosity, which we all have, and the fact that we as Canadians pride ourselves in the rule of law and pride ourselves on conformity with international treaties. We sometimes honor it in the breach, and we're not always there, at least there are questions. But it is a relevant question to ask whether or not the law that we've enacted does comply with the treaties that we've agreed with our trading partners to abide by. The second is, of course, there are potential implications for being offside a treaty. You could be subject to a trade challenge. Of course, whether you will or not involves a lot of politics with your trading nations. You could be offside, but they decide not to take a run at you for lots of reasons. But it still is something that a number of people would take into account. And then the last reason is that where a statute, including a copyright statute, is ambiguous, courts have said over and over again, including the Supreme Court, that you can resort to international treaties as an aid in interpreting a statute. Now, where the statute is clear, the courts will give it the meaning of the words. But where there is an ambiguity, and there's a number of ambiguities, as we've heard today in the UGC section, it could well be at some point someone will argue that the treaties to which we're a party to should be considered, at least, in considering some of the scope of the provisions. Now, many of you know that we're a member of the leading treaties, the Berne Convention, the Phonograms, Rome Convention, and TRIPS, and many of the WCT and WPPT provisions are already in effect. We've started the ratification process and will be a member of the WPPT probably in 4 or 5 months. And these treaties require Canada to provide certain protections. And when you look at the treaties, you all know what exclusive rights we have in the Act. And many of these rights historically were enacted to be in conformity with the treaties that we're a party to. And so when you look at our Act and you look at the treaties, you know that we're required to provide protection for reproductions. Under Section 12 of the Berne, there's a requirement for protection for adaptations, arrangements, and making alterations of literary and artistic works. And many of you know that the term literary and artistic works is a term of art under the Berne Convention, which includes a variety of works, including musical works, what we think of as being literary and artistic work, and many dramatic works. And then in Section 14 of the Berne, there is another right related to adaptations, which is the right to create adaptations of this long list of works, to create cinematographic works, and then also rights to communicate them to the public by wire. And then we know both under the Berne and under the WCT and WPPT, there are rights of making available to the public. And as you all know as well, in treaties like the Berne, Article 6A requires protection for moral rights. Now, it's well recognized at the international level, and as a matter of public policy, that there are and should be exceptions to exclusive rights. And the treaties provide the rules, the international norms, for the contours of the exceptions. And the most usual formulation that you see in the treaties is what's called the three-step test, sometimes referred to as the Berne three-step test, because that was the first treaty in which it was found. And you need to recognize that the three-step test applies slightly differently from treaty to treaty in terms of what is accepted and what is not. So for example, the three-step test under TRIPS applies to all of the rights that have to be protected, whereas under the Berne, the three-step test only applies to the reproduction right, doesn't apply to all of the rights. And so I just start off before I get to the three-step test, because I'm going to spend a little bit of time on the three-step test, and just have you think about whether or not the UGC exception right off the bat is compliant with the Berne Convention, which requires, as I mentioned before, protection for adaptations, arrangements, and other alterations. And when you think about what the scope of that is under the Berne Convention, it applies to a long variety of derivative works, sequels, abridgments, a localization, modifications, converting a book into a movie or a movie into a game, arrangements of pre-existing works, and would probably cover creation of mashups and fan fiction. And again, I mentioned that the Berne Convention, Article 14, deals with adaptations for the purpose of creating cinematographic works, and then the dissemination, communication of the cinematographic works to the public. And when you think about these rights under the Berne, and you recognize that there's no explicit exception under the Berne to these rights, you have to ask the question, where is the exception at the international level to Articles 12 and 14 that would enable Canada to enact the UGC exception, which, as people had mentioned already, enables individuals to take any existing work and to create a new work. They can use the existing work to create a new work. The word use, as people has mentioned, is broadly defined. That includes all exclusive rights except the right to authorize, which would include creating adaptations. So I kind of just raise this, and perhaps others will be able to say, look, Sukhman, of course there's another exception, and here it is, and I'd love to hear what you all think it is. I want to turn now to the three-step test, which is, again, the test that you find in all of the treaties. And you'll see here the formulations under Berne, TRIPS, and WCT. And by the way, I'm sure if there is an exception, Professor Vaver will tell us what it is. So that's a question to Professor Vaver and to Professor Navin later to tell us whether or not there is an exception to Articles 12 and 14 that lets us do this. So you think about it. That's some homework. So under the Berne Convention, you'll see the formulation is that there can be exceptions as long as they don't conflict with a normal exploitation of the work and don't unreasonably prejudice the legitimate interest of the author, and it applies only in certain special cases. So the magic words that you see in all the treaties are, it's got to be a certain special case, it can't conflict with normal exploitation, and doesn't unreasonably prejudice the legitimate interests of the author. So that's the formulation you see. There are differences between them in that the Berne applies to, if you look at the wording at the end, the interest of the author, as does the WCT. TRIPS applies to the interests of the rights holder. Now, let's just take a look at some of these terms and what they actually mean. Now, you'll see a slide at the end of this slide where I've got references to the leading text and authoritative interpretations, at least in my view, of the three-step test. So you're all commended to look at it to see the sources for this, and these slides would have taken too much room. But again, at a high level, I think here's a a decent way to understand each of the 3 steps. So certain special cases has been interpreted to say that the exception has to have a certain predictability requirement. It must be clearly defined, known, and particularized. So you know what it is. When you see it, you can define it. And then it must be limited in scope. So it's got to be finite and limited in scope. And one of the formulations you often hear is it must be narrow in scope and reach. Narrow in scope, narrow in reach. And then there is a third requirement which the academics debate whether is part of the 3-step test. I'm certainly not going to resolve it here, but there's a suggestion in some of the literature that it also requires that the exception serve some specific and sound public policy objective. So is the UGC exception a certain special case? Well, I think to answer that question, you have to look at the words in the exception. You'll see it applies to all existing works and subject matter. Computer programs, engineering drawings, dramatic works, musical works, every kind of work under the Act, not simply musical works and cinematographic works, which were mentioned during the reform process. It also exempts all uses of existing works. And I suggest that there isn't any explicit reference to transformation. There has to be a new work, which is either, depending on how you interpret the word new, it's either original, new in some sui generis sense, or new in the inventive sense. I'd probably say that the consensus around the room is that it's new means original. But again, that could be anything under the sun as long as there's a sufficient amount of skill and judgment. And then there's a right in the right to use the new work. Again, the right to use means to exercise any right of the copyright holder, again, making it fairly broad. And there's a right to authorize the dissemination of the work, which again makes it fairly broad. And it is subject to a number of restrictions, including the exception that it has to be non-commercial, and there's questions about what non-commercial means, going to the area of predictability, and also whose use is relevant for considering non-commercial. So I leave it to you when you consider the nature of the exception to come to the conclusion as to whether or not it is narrow in scope and reach, and whether or not it is sufficiently particular and well-defined. The second step is normal exploitation. Now again, there's different formulations of what normal exploitation means. It's, in one formulation, a usage that the copyright owner would ordinarily expect or seek to exploit. All forms of exploitation, which either currently or could have economic or practical importance, can't undermine a market or undermine the ways the rights holder normally would extract economic value. So if you think about how rights holders extract value, they often do it from licensing. And we heard 2 examples today. We heard about licensing by I think David Baskin was talking about licensing the mechanical right, and we heard Eric talk about licensing the performance right. In fact, entering into transactions with YouTube. And there are lots and lots of normal exploitation which involve licensing, including licensing of UGC works. And so there is a question about whether or not the exemption does or does not meet that condition. Now, in order to try to fall within the condition, the exception has this condition in it. That is, that the use or the authorization to disseminate the new work doesn't have And we talked about this before, a substantial adverse effect, financial or otherwise, on the exploitation, or is not a substitute for the existing work. And so one of the questions that you need to think about is whether or not there is a perfect match, or at least a good enough match, between the normal exploitation test and the way in which this exception is formulated. And there's lots of questions about how it will be applied. Does the test that looks at substantial adverse effect, is that going to be applied on an individual level? An individual can have a substantial adverse effect, and the next guy can have a substantial adverse effect? Or does it have to take into consideration a much broader view? Also, does the court have to take into consideration only the impact of the authorization to disseminate, or does it have to take into account the ultimate effect of the dissemination, which isn't right in the wording? So there are lots of questions about it. And I know I've got this word, I can barely read END, so I'm going to be fairly quick. I always have problems in reading something that's far. The next step in the three-step test is unreasonably prejudiced legitimate interests. And this covers a number of things. And it's not simply the economic effect, but it also covers non-economic interests that are justified. It has to be a legitimate interest. And it's one where there can be some effect. It simply can't unreasonably prejudice. And so the question here is whether or not the exception has sufficient protections to ensure that there isn't unreasonable prejudice. And so when you look at the section in a careful way, we realize that there is protection in the Act already for moral rights that covers certain uses where an author's honor and reputation is going to be prejudiced, a subjective test applied, reasonably held. And as well, there is an exception for usage in conjunction with a product, service, cause, or institution. But apart from that, the question to consider is whether or not there is anything in the exception that deals with effects that are non-economic. And when you look at the exception, it talks about financial or otherwise dealing with the exploitation. There's nothing specific in the exception that deals with other considerations that authors might find important. And there was a talk earlier about the relationship between the author and their character. And maybe an author would be really upset about the use of their character in association with a different kind of work or a different kind of use. Not necessarily because it injures their reputation and they can prove it, but because that's not how they wanted their work to be used. I mean, they might object as well on literary, artistic, moral, political, or other grounds. They might not like the juxtaposition of their work with other things that they may find objectionable. And it's this third step in the three-step test that takes into account those considerations. And I just ask you, where in the exception is this dealt with? And is it dealt with satisfactorily under the moral rights section? There are a number of references in the slides that I commend you to read, and if I'm going to talk about any of them, I suggest you read Dr. Fischor's paper, which very specifically looks at the three-step test and compliance with the Berne Convention. He wrote it in conjunction, or at the time copyright reform was in play. And if you go to his site, he just published a paper today on the Marrakesh Treaty. You might want to read that as well. Thank you very much.
Thank you, Barry. For someone who is intent on making sure we abide by the rules, I'm glad that you took a liberal view of what end means. Okay. Could I now ask Professor Blom, Joost Blom, to talk, please?
Well, thank you very much, Pina and other organizers of this workshop, for having included private international law in your thinking and for having asked me to speak to it. Thank you all for staying here to listen to it. As David mentioned in his introduction, there's really two levels of international complexity to be addressed. One which Barry has just talked about is what are Canada's international obligations, and how does this proposed UGC exception fit into that? But private international law addresses a whole different set of questions, which is how does intellectual property basically play out within the legal systems of each country. So private international law is how the legal system itself deals with the cross-border aspects of each field. And so it usually is taken to deal with three questions. Well, first is the jurisdiction question. And now, that is, where can I be sued? If you're looking at it from the point of view of the potential wrongdoer, which court has jurisdiction? And that is a question that, if you're asking, well, does a Canadian court have jurisdiction? Where do you find this information? Well, you find it partly in the rules of court of our different courts, and they do differ somewhat from one province to another. Partly in statute. In Quebec, it's in the civil code. In some common law provinces, there is a statute dealing with jurisdiction as well. So there's a variety of sources for this. But basically, wherever you are, whichever court you're dealing with, you can look it up and find out whether or not a particular case that has cross-border sort of aspects can be heard in that court. I mean, if two parties agree it can be heard there, then things are relatively simple. If you're trying to get an unwilling party into court, that's where the thing gets more complicated. Then there's a choice of law aspect to cross-border problems. If I'm sued in a particular country, is the court in that country going to apply its law or the law of a foreign some jurisdiction that is foreign to it? So looking at it from a Canadian jurisdiction's point of view, if you're in an Ontario court, when is an Ontario court going to apply a foreign law? And it often does. In a contracts may come before an Ontario court that are not entered into under the law of Ontario. And so it is common for Ontario courts to be adjudicating contracts that are subject to the law of another jurisdiction. And what happens there is, for those, and I know there are non-lawyers here, and I should tell you that even for lawyers, private international law is a subject that makes most lawyers go green about the gills. It can look very complicated, and most lawyers kind of treat it as if it's radioactive, but some lawyers are fascinated by it, rightly. And so, but one of the issues is, when is a court going to apply foreign law? And then the third question, which is actually going to be a bit in the background in the few comments that I've got, are if I'm sued in one country or jurisdiction and lose, is that judgment, whatever it is, against me or not in my favor, is it going to be enforceable against my assets in my home country? Now, those are the general problems that private international law deals with. So in the general system, and I'm going to talk about the general system for a bit, and then try and explain why intellectual property poses a very specific set of difficulties when it comes to plugging it into this general system. Generally, jurisdiction and choice of law are two different things, as I've already sort of indicated. A defendant can be sued in its home jurisdiction no matter what the cause of action is, because you can always sue somebody where they live. And you may well be suing them on a marriage that they entered into abroad or a contract they made abroad, doesn't matter. And if necessary, or if the rules permit it, a court will apply foreign law to determine what the parties' rights are. Usually, you can also sue somebody in the jurisdiction where their alleged wrong took place. So they don't live there, but they did something there. Or they did something that had an effect there, and this is where the things get a little difficult, is just how far does a court have jurisdiction to look at cases where the defendant isn't there, hasn't agreed to be there, but nevertheless did something which had an impact in the jurisdiction, and usually a local plaintiff, a local litigant, wants the court to do something about it. And where the defendant can be sued this is really just a repetition, is not tied to the law that applies to the wrong. So the rules for jurisdiction are not tied to the law that's got to be applied, usually. The rules for jurisdiction are, by and large, geared to where the defendant is and where the defendant has acted or should be taken to have acted. So that's the sort of the basic layout of the jurisdiction question. Now, what about IP? Well, there's a couple of things that make intellectual property rights different from regular civil, in the sense of private rights, like contract or claims in tort or something like that. Because IP rights are, in every country, the creation of legislation. They differ from one country to another, although all those conventions that Barry was talking about set out ground rules that at least the parties to those conventions have to respect. And the other thing about it is that and this is really one of the difficulties, IP rights are usually limited to the territory in which the rights are to be exercised. So where does Canadian copyright law, what does it apply to? Well, it applies to, basically, to acts of infringement in Canada. Copyright law gives authors, that is owners of copyright, or it gives sound recording makers and so on, the neighboring rights. It gives them rights, the exclusive right to do certain things in Canada. And so the Canadian Act applies when somebody is infringing that right in Canada. And so if the acts, one sort of gray area is, well, what if the location of the infringement is not clear? And this came up in the SOCAN case a few years ago, in 2004, dealing with, well, to what extent can Canadian copyright law reach internet communications? And the question, the Copyright Board had said, well, gee, it seems sensible to us to make it depend on where the server is located. And the Canadian Supreme Court said, no, that's too mechanical a test, and we think the proper construction to be given to the Act, because Parliament has not sort of explicitly said how far the Act is to reach beyond the borders of Canada. The proper assumption to make is the one that Barry referred to, that Canada will act in accordance with its international obligations and won't exceed its international rights, and its international right, according to the Supreme Court, extends to any, so far as that communication issue is concerned, communications over the internet, it extended to any communication that had a real and substantial connection with Canada. That phrase, real and substantial connection, is one of which the Supreme Court is exceedingly, some would say excessively fond. It's an all-purpose kind of attempt, at least, to give substance to what is really not, what is really an inherently unclear concept. But anyway, so internet transmissions, the legislation or the tariffs that are authorized by the Copyright Board are not strictly limited by territory, but they are limited by connection with Canada. So with IP, the problem is, as I've mentioned, that the rights are territorially limited. Your rights under the Canadian Act are rights that only apply within Canada. Well, does that, unlike the normal position in private international law, which is where you can go to any court and ask them to deal with foreign rights, rights that are from laws other than their own, does that apply to IP, given that these rights are so strictly territorial? In other words, if you want to get a remedy for a breach of Canadian copyright, do you have to go to a Canadian court? And if you want a remedy for a breach of US copyright, do you have to go to a US court, and so on? Well, that's actually a very fraught question. And the assumption until recent years has been that each country's courts really can only deal with IP rights within their territory. So if you have a copyright, well, if you have, let's say, copyright in 50 countries, and there are infringements going on in all 50, you have to go to courts in all 50 if you want a total remedy. That is obviously very awkward. It makes sense, and it does clearly, it is the rule, if you're dealing with things like patent rights, which depend on a registry, because each country has its own registry subject to treaty, and you have to go to the jurisdiction where the registry is in order to get a court that can do something about the registry. So, but copyright's different. Copyright is not tied to registration. And so the more recent view, which came up in a United Kingdom Supreme Court case, was, and this is the case that was referred to earlier about the replica stormtroopers' helmets that a sort of an English technician was selling over the internet to American customers, and that's the $20 million judgment David Vaver referred to earlier. The issue before the UK Supreme Court was, can the UK court give a remedy for breach of American copyright? And for the first time, the highest court in a country took the view that yes, you could. There's no reason why a UK court couldn't give relief for an infringement of American copyright. I should mention that this whole area of private international law and intellectual property has been the subject of a lot of work in recent years, particularly in two venues. One is the American Law Institute, and the other is the Max Planck group, which is based out of the Max Planck Institute in Heidelberg. And each has come out with a very comprehensive, very thoroughly researched report on really not the law as it is exclusively, but also the law as they think it ought to develop. And one of the positions that both of those studies took is consistent with the Lucasfilm proposition that if you go to court in country A, that court might, if it wished, deal with copyrights in other countries, not just the copyright in its own country. Now, if you're looking at things from a Canadian resident potential infringer, I'm getting the 1-minute signal here, the questions to consider are, what law applies or may apply to my activity? Is it Canadian? Is it foreign law? And then once you've sort of got your mind around that, you can ask, well, if I'm infringing Canadian copyright, can I be sued for it in Canada? Well, the answer there is yes, because you're in Canada. If you can you be sued for it elsewhere? Well, possibly. if the Lucasfilm is that approach is taken elsewhere. But usually there's not much point for doing that. If it's Canadian copyright, that's an issue. If I'm in breach of a foreign country's copyright law, can I be sued for it in that country? Yes, usually, but you're not there, let's assume. You have no assets there. And so going against you in that country, they may have jurisdiction to do it because what you did infringed the laws of that country. There'll always be jurisdiction to proceed, but enforcing any resulting judgment against you may be an issue if you don't have any presence or interests in that country. Can they come to follow you here? Well, that's what happened in Lucasfilm. They followed the wrongdoer to his home, and the court there did take jurisdiction and apply U.S. law, but awarded a judgment, as David pointed out, for a lot less than the U.S. court had done when basically the defendant hadn't defended. So what copyright laws, I finally get to UGC, what copyright laws apply to user-generated content? Well, number of issues, which I don't need to repeat for you. You've been listening to them all day. Is it a breach of someone else's copyright to incorporate the original material? Do you fall within an exemption for fair dealing, the new specific UGC exemption? But here's the critical point. The law that applies to the infringement is that of the country in which the reproduction, whatever it is, the reproduction, the performance, or the communication takes place. So if I can have one more overhang my time here and just give you one example. A group of students at UBC in Vancouver make a video, and I was inspired by a particular video they made in one of those flash mob sort of videos with 8 million students all singing to a soundtrack. The images are all made by the students, but they use copyright songs as the soundtrack. And they show the video at UBC student events and upload it to YouTube. Had I known about the agreement with SOCAN, I might have worked that into the example, but I didn't. Copyright in each musical work, that the Canadian copyright, is potentially infringed by making the reproduction, by performing the work in public, and by communicating the work to the public. A and B happen in Canada, but C, communicating the work to the public, if you upload it to YouTube, well, it's being communicated all over the place. And so the copyright laws that are engaged include the laws of any place where that YouTube video is seen. And then we come back to this is counterintuitive for people because they think, well, I'm acting under Canadian law. Yes, that's right, as long as what you do stays in Canada, but as soon as you are posting things that can be seen abroad, you're into their legal system and with whatever consequences that has. And the exemptions, whatever exemptions you're entitled to, would also be a matter for that foreign law, not Canadian law. So I'll just flash these by you. You could enforce against the students, you could enforce the Canadian copyright in Canada. The foreign copyright, you could go in the country where the law was infringed. If the video were covered, it might be, by the new section 29.21, it would protect them against Canadian infringement liability, but not against foreign infringement liability, because that depends on what exceptions the relevant foreign law has and would apply. And just one other thing, sorry, I'm really overstretching it here. You should know that if a foreign court gives judgment against a Canadian, even if they don't defend, and Canada is much more liberal in this than most countries, we will enforce the judgment here, so long as here it is again, as long as there was a real and substantial connection between the litigation and the foreign country. Well, if it's a copyright infringement litigation, there's bound to be a real and substantial connection with the country whose law is infringed. So money judgments are automatically enforceable here, which can be very large amounts of money. And even non-monetary judgments are now subject to some discretion, potentially enforceable here too. Okay, I think that's as much time as I can legitimately take. Thank you.
Thank you very much indeed, Joost, for that tour d'horizon. Questions from the floor? Come up to here.
My name is Pascal Chapdelaine. I first want to congratulate all the speakers today for excellent presentations. I have two questions. My first question is to Barry, and my other question is to members of the panel, or maybe someone else would answer the question. So Barry, you raised important points about the compliance of UGC, the new provision, with international conventions. How would you contrast that with compliance with fair use and fair dealing with international conventions, two provisions in US copyright law and in Canadian copyright law that have been there for a long time? My second question pertains to something we have not discussed much today, and this is the intersection or the tension between moral rights and UGC. And I would ask the question to lawyers and to artists: how do we reconcile the tension between what moral rights seek to protect and UGC? Thank you.
Well, thank you for those two good questions. Let me answer the first one, and then we'll maybe both take the second one. And the issue of compliance by the United States and a couple other countries around the world that have fair use is a really interesting one. And the argument often is, well, the United States has fair use, therefore it must comply, or at least if they're doing it, anybody can do anything that's comparable. If you look at the academic literature as to whether or not US fair use actually complies, there's quite a lot of literature expressing the opinion that it doesn't. And there's a number of reasons for that. I won't go into it, but there is a lot of debate among erudite academics as to whether or not it does comply. The United States might have been a special case given when it came into the Berne Convention, the fact that it already had fair use, and so some of them have there's been arguments made that it's a special case, although there is no such thing as that kind of special case. A number of countries have considered whether to implement fair use. UK did it, Australia did it, and in those studies, they looked at whether or not fair use complied with the three-step test. And in those two countries, when they refused or decided not to go ahead with fair use as an exception, there were a number of policy reasons, but a reason given both in Australia and in the UK was the doubt that fair use actually did comply with the three-step test. Now, I know there's a lot of debate and it's a hot topic among academics, but I can just tell you that there is that that concern, and nobody, as far as I know, is taking the United States to a dispute on TRIPS on it, though.
Well, I think the reality is when WIPO was so enthused about getting the United States to become a member of the Berne Convention that it produced a report saying, well, everything you do is compliant with Berne, there's no problem, just come along. Perhaps the registry is a problem, so registration you've got to do, but things like fair use, no problem. Which seems to me to say that if that's true for the United States, as Barry quite rightly points out, there's not one rule for the although the United States believes in exceptionalism, but the rest of us believe that there is not one rule for the United States in regard to fair use and Berne, and other rules for the rest of us. And if that's true of Berne, it's got to be true of TRIPS. I'm not quite sanguine about the fair use exception. Really, as you say, no one is going to sue on the United States about the lack of fair use or the fair use issue being non-compliant with burn-or trips. And that being so, it will not lie in the mouth of the United States to try a suit against anybody else either. The moral rights question is really interesting. Do you want to have a shot at that, Joost?
Well, I'll have a shot at it, although I don't have any particular wisdom to offer on it. But yeah, in fact, one of my students in my IP course asked more or less the same question. What about this? And it raises the whole, it's the intersection between the honor and prejudice standard and the user-generated content. And so some authors, and as Barry said, some authors may take the view, I'm happy to have all my stuff used in this way because people are more aware of my work and it's all fun and all good. But some authors may not like being associated with whatever the product is or whatever the particular new work is. I don't think there is a way to resolve it. One of our handicaps in this is that, at least as far as Canadian law is concerned, we've got precious little guidance from the courts on what the standard is, and in particular how far you defer to the author's own feelings on these matters, and how far you apply some kind of objective test of whether they ought to feel prejudiced or in any way. So it's an excellent question. It would have been, yeah, you can put a panel on that one, although it's bound to be inconclusive, I think. I don't think there is a hard answer to it. But I think a lot of user-generated content of the kind that we've been looking at, like particularly this morning, would have a tough time meeting the honor and prejudice, the prejudice to honor and reputation test, I think, because the use made is so, it's one of like 100 different things that all pop up in that one work. But the more prominent the original is, I think the more you get into the question you've raised. Yeah.
So I'll make just one comment, which is I think we're going to see more cases involving moral rights in any case involving UGC, because where a rights holder has a concern about UGC, sometimes they may not care, but where they do care, given the way the section is worded, they will look for other avenues. And a case in point, just to go back to history in Canada, if you remember the case involving Nintendo and Comerica involving the game Genie, which, interestingly from a UGC perspective, let users play the game in a different way by giving you different lives, new levels, and so forth. And Nintendo sued Comerica, which was a distributor of the game Genie, and they had a fairly weak case on copyright. And so in aid of their case, they brought in Mr. Miyamoto, who was the world's greatest game designer in his mind, well known in Japan. And he said, "This destroys my game. I never intended it to be played this way." And he went on and on and on in his affidavit, and in his discovery went even longer. But at the end of the day, he couldn't prove he had a reputation in Canada, and so it lost. But the point is that where there is going to be this kind of claim, I expect to see more cases involving authors who are purporting to assert their rights.
Well, David Baskin's coming up, so I'll just ask, and I'll take David first, then I'll take you, but I'll just making this comment. I just wonder whether the climate of the internet now means that moral rights are not going to be taken as seriously as they once were by the Nintendos and Michael Snows of the world. I think perhaps the rule of stiff upper lip ought to prevail rather more there, and perhaps does already prevail rather more there than one expects.
I want to also commend all the speakers for their excellent presentations, and actually I'm very glad that this subject wrapped up today, because I've long felt that, as Shakespeare almost said, jurisdiction is all. First of all, on the question of moral rights, Barry, I agree, it's a question of great importance, but the principal governor on that is the insuperable cost of litigation, which renders it as beyond reach as the stars for individual artists. It's simply inaccessible and always will be, and just getting worse. And even for most companies, when it's a question of what you're going to invest in, you can simulate litigation by shredding your money and setting fire to it. It's not going to give you any reasonable remedy, and sadly, and that's a tragedy considering how important moral rights are. The second point is that I don't think anything could really be more telling in the end than the question of jurisdiction, particularly the applicability of Canadian law to activities in Canada whose actual origin and action come from outside Canada. And in that regard, it's important to remember that every single internet service that we talk about as being of relevance or interest in the commercial or cultural context originates from outside Canada, either France, perhaps from the UK, or almost invariably from the United States. The Copyright Board, in its decision on the liability of Sirius XM for the reproduction of works within Canada, essentially terminated the rights of authors and publishers by saying, well, the servers aren't in Canada except for 1 or 2 channels. That was upheld by the Federal Court of Appeal, and that effectively, notwithstanding the court's observation that the reference to the location of the server was perhaps an unduly mechanical kind of criterion, it's a very real criterion. So that means that the smart infringer will forum shop for the jurisdiction with the weakest copyright protection, because on a practical basis, it means you can do anything you want from there. And indeed, the prospect of the creation of copyright havens is not at all excessive rhetoric. And perhaps it behooves the smarter country looking for some rent from, Grand Cayman Islands of copyright, perhaps. I think it's indeed a serious problem, because, in my former capacity running CMRA, we ran into a very large international well-known company, whose name you'd know in a moment, which said, we're not going to pay your price. There's a world price because the internet's a world medium, and we're operating throughout the world, and we will say what the world price is, and we're not interested in you or your board or your laws or your tariffs. We'll tell you what the deal is, or we won't come at all. And the public will say, why don't we have access in Canada? And you know who gets pointed at as being the bad guy in this equation. It's a terribly difficult situation when the real motivation in the whole marketplace comes from outside Canada, but the consumption happens within Canada. Anyway, thank you for your presentations.
Thank you, David.
My name is Mona Zarifi, and I'm a second-year law student at Osgoode. My question is basically concerning the direction of international copyright law and how far we're willing to go as far as protecting potential markets of original works. I understand that in the U.S., when assessing fair dealings, we look a lot to the impact of the market, and as I guess 29.21D suggests, is we also look to the potential markets as well. So my concern is just basically, I conjured up a situation in my head where, what if a user-generated content really has no impact of the potential market in Canada, but it does affect it somewhere else? How far is international copyright willing to go to protect the markets of other countries? I don't know if that's a tangent or not, so thank you.
That's a good question. It actually spans both speakers' topics.
Yeah, no, I think that's a great question. First, David, I totally agree with you about the prohibitive costs of litigation. And when you create multiple exceptions, you have to realize that it enables uses, and it's very expensive to litigate. On the other question, you raise really good questions, because when you examine D, there are a number of questions there about what it applies to. Again, ordinarily, as Professor Blom was indicating, Canada's Act applies on a territorial basis, subject to the real and substantial connection test. And the real substantial connection test applied to the communication of the public right because things were happening here and there. But in the serious case that David was talking about, where there was an upload from Canada to a U.S. server, the reproduction right doesn't happen here or there. It happens where the copy is materialized. So the real and substantial connection test doesn't apply. So when you look at D, a good question to ask is whether or not the real and substantial connection test will apply to each of the various attributes of each of the different pieces of the condition, and then whether or not it's the real and substantial connection test or something else. So when it talks about the use, for example, is that the use in Canada? Is that the use in Canada and elsewhere? Again, is it happening here? Is it happening there? And again, that's from a Canadian's perspective or from a foreign perspective. The authorization to disseminate raises the same question. Is it the place in which the authorization is given? Probably not. Is it the place in which the person who's going to disseminate resides or is carrying on? And the answer probably is yes. And so if you look at that, you'd say, okay, the authorization to disseminate, is that to disseminate only in Canada on a UGC or US site, or is it an authorization to disseminate outside of Canada? And again, it'd be a question about what's the right conflicts of law principle to apply. Is it real and substantial connection, or is it something else? And if the dissemination is wholly outside of Canada, is it caught at all? And then you get to the question you asked, which is the substantial adverse effect on the exploitation or potential exploitation. And the question is, where is that effect to be considered? Is it solely in Canada? Is it in Canada and in other places in which there's a harm to the market? And you can imagine on the internet, you could have harms. You've got companies doing business globally on the internet. And so is it appropriate only to look at the harm in Canada? Or is it also appropriate to recognize that harm can take place in every place in which the work can be accessed and for which there's no payment? So the question you raise is a really good one, and it's going to come up because we've got activity in foreign sites that are going to be accessed in Canada. We've got Canadians who are going to be uploading both in Canada and elsewhere. And so the question that Professor Blom talks about is a really relevant question, and there are going to be some really good faith discussions about how each of these factors applies when you look at the conflicts of law analysis. Now, you're the expert, so you tell us what the answers to that is.
I'm not that foolish, but I mean, I agree absolutely with the way you've sort of analyzed it, and I think actually there's a pretty good argument if a UGC user, the one who's sort of doing all this, is in Canada, and the court is being asked, and this plugs back into the question about cost. I mean, when you have an exception that is so judgment-driven, how you have to get before a judge before you know what your rights are. But let's assume you do get before a judge. Can you say, look, Judge, the adverse effects on me in Canada are admittedly minimal, but the natural consequence of what this person is proposing to do for non-commercial use is going to have spillover effects in other countries, and that's really going to hurt me. And I think there's a good argument for saying that this is a case where Parliament maybe has authorized you to look at the extraterritorial consequences of the intra-Canadian activity, because the policy of the exception, I think, arguably, is driven by the idea, well, what this person's proposing to do isn't going to do any harm, and I don't see why you can't say that means doing harm anywhere, not just in Canada. Because you're not talking about whether there's taking into account what this is going to do in another country is not taking jurisdiction over some infringement in other countries, but you're deciding whether an exception to infringement should apply within Canada.
Well, this sounds like a paper that Pina was looking for everyone to publish. So just a plug for IP Osgoode trying to publish a paper on this. This would be rife for your expertise on the intersection of conflicts of law and IP.
Well, I think we have probably come to... Did you want to say something, Philip? I think let's make it literally that,
All right,
less.
I think I can make it very quickly. I just wanted to, well, first
Philip
of all...
Poles.
Oh, yes, sorry. I'm Philip Poles. I'm an articling student at Blackberry. And I want to say thank you very much. And I wanted to maybe try to unpack the problem you just unpacked with jurisdictions where now we haven't looked a lot at service providers and liability from a service provider perspective. But if we have a provider whose servers and operations are in Canada, but the users are outside, and so the replication is certainly taking part in Canada, the reproduction, I should say, is taking part in Canada, but users may be inside or outside of Canada on either end of it, can we unpack it the same way, or do we have to start by applying, jurisdictional rules in all of the jurisdictions in the world, and then choice of law, and then start looking at the copyright implications?
I think that one's literally 30 seconds each on this.
Well, there is, in those two international sort of studies that I mentioned, there is a suggestion that all legal systems might work towards some agreement on ubiquitous infringement, where you're having sort of one set of actions leading to infringement under multiple states' laws, and that you really work out a system where you decide the case really under either one or just the states that are predominantly affected by it all, and then everybody else kind of has to take whatever they can get under that system. So precisely because of this difficulty that people really don't know where they stand, and with borders being as porous as they are now, it's almost impossible to advise someone what they safely can do, because you'd have to advise them on all of these different legal systems.
So let me try to unpack that in 32 seconds. A work that is transmitted and stored on a Canadian server from outside of Canada. So first, the UGC exception applies to the individual and to the authorization the individual gives. It doesn't actually create an exemption for the service provider that's hosting it. So you have actually a different analysis. It's not a UGC analysis at all. It's whether or not the hosting exemption would apply to the host. It's a question of whether the host is making available or communicating, or whether it's the user who's uploaded it who's communicating it or making available. When you get to, and that's kind of the Canadian position, when you then say, okay, do they have liability outside? Again, it becomes more complicated, because the user who's uploading it, the user, when it goes out of Canada, right? The user, there's a question about, are they liable on some contributory theory, on some, depending on the country, authorization theory, and then there's a question about if the host is the communicator or is making available, right? Does that host have liability outside of Canada? And that's a more difficult question. It'll take me another 20 seconds, so we don't have time for it.
Thank you very much. Thanks, Philip. Thank you very much for the speakers. We started off with art and we've descended into fog. So I think quite appropriately for a legal conference, but we have, I think, a final speaker who will lift the mist. In the meantime, can I thank, on your behalf, the two speakers.